in the
Okay, looks like recording started.
Good. Shall
Go
we
ahead.
go?
Yep.
Hey, hi, good evening, everyone. Welcome to the webinar of TTA for the immigration laws. So before that, we would like to inform this call is only conducted for the purpose of assisting the immigration and not for the legal advices. So if you have any questions, at the last, we'll be providing the details of our attorneys and you can contact them. Yes. So this webinar is conducted by our Telangana American Telugu Association, which is called as TTA. It is founded by our founder Pilla Malla Reddy Garu
Paila.
Paila Malla Reddy Garu after the separation of the states. So he's known for his the prominence and his helping nature. And I would like to introduce our President Naveen Reddy Garu. He's on the call. So Naveen Reddy Garu, can you please introduce by yourself?
Oh, thank you, Wasabi. Thanks to Phoenix team. You did awesome job. This is the first webinar for TTA for 2025. And thank you very much. And thanks to our founder, Pailamala Reddy Garu, and Advisory Council, Jayapal Reddy Garu, Mohan Reddy Garu, Bharat Garu, and Srinu Garu. And yeah, this is the first webinar. And thanks to Bhanu and Sai for talking to all these. This is a major issue going on right now. And thank you for all the Phoenix team, Praveen and Jyoti Garu, and thanks to all our RVPs. Thank you.
And Vasavi, we also have our TTA advisory chair, Vijaypal Garu.
Yes, Vijaypal.
Okay. Sorry for the discrepancy.
Vijaypal, can you please share your remarks?
Recording in progress.
Shiva, there are 4 Vijay's. I don't know whether uncle is on the call. Let me text him.
so Vasvi, let's move now. Like
Continue.
Yeah, go ahead.
We can continue. That's fine.
Go ahead.
Yeah, Vijaypal Garu, advisory member, and he is there to help us anytime for anyone. And it is a great to work with Vijaypal Garu. And he can talk later, Praveen brother.
Okay.
So let's move on. Yeah.
Okay. Sorry, there was a small thing. And from the we are the chapter of Arizona. So the TTA was spread into multiple states. So we are proud to say that we are the first one who are conducting the webinar on the immigration from the TTA Arizona. So we have our board of director, the Praveen Shamala, and where the Jyoti Reddy Dulpala, everyone knows she's the women service with she's known for her women services, and she's an international service director. So where they are delivering their services to the Telugu community. And I welcome all Arizona chapters, RSV, the RVPs, and everyone who are servicing for the TTA Arizona. So yeah, well, Praveen and Jyoti Garu, can you please introduce yourself?
Yeah, myself, Jyoti Reddy, and working with the TTA from long time, and it is great to work with President Naveen Garu and our founder, great personality, Paila Mallareddy Garu, and advisory member of TTA from long time, Vijaypal Reddy Garu, and Mohan Patlola Garu and Bharat Garu. All these people inspired personalities to work with from long years. And definitely EC, all members, and all extended EC members and BODs, all new blood in TTA now. And my brother BOD from Arizona State, Praveen Samala, one of the great personality work with, and he is young and dynamic. Definitely TTA is going to fly high from Arizona State. And all RVPs from Arizona who is working very hard from couple days for this webinar. and it is going great, and I hope it will fly high. All issues can be addressed by our two great lawyers there. Thank you.
Thank you. This is Praveen Samala. I'm the board of directors for TTA, and I would like to thank our leadership team for the opportunity for Arizona chapter. And definitely, this is a great initiative and a need of the hour because like we're hearing a lot of noise about what's going on with the immigration after Trump's new administration. So let's leverage maximum out of it, and hope everyone enjoys the session. And I'm sure like Bhanu Garu and Sai Manthra Garu are going to provide us a lot of informative. This is definitely going to be an informative session, and they're going to provide a lot of insights about latest immigration changes. Thanks everyone, and Vasu, I think like let's get started.
Okay. So we have our guest speakers, Bhanu, Babu Ilindra Garu, and our another guest we have Sai Manthra Garu. So Bhanu B. Ilindra Garu is attorney at law from BBI Law Group. So he was seasoned with attorney of 19 years of experience and providing the expert legal counsel specializing in all immigration laws. So in this webinar, we are going to discuss what are the new changes are going to come. We have numerous questions. So we will be clarifying all the questions. If you have any questions, please post it in your channel. And yes, Bhanu Garu, please, can you introduce yourself?
Thank you, Vasavi. And first of all, I would like to thank Naveen Garu, Praveen Garu, Jyoti Garu, and everybody in the TTA, Paila Mallareddy Garu, and because of the doing amazing job and amazing service by the TTA for our community. And thank you very much for giving this opportunity for me to be part of this webinar where we are trying to provide latest updates or bring general awareness about the immigration laws to the community. And as you said, I've been practicing immigration law for more than 19 years. I'm the founder of BBA Law Group PC. We are exclusively immigration law firm. We represent more than 1,000 companies in the country, and we represent in all types of immigration matters: employment-based immigration, family-based immigration, EB-5, investor visas. We do Department of Labor audits, I-9 audits. I mean, we do certain removal proceeding cases also, but not everything, but certain cases, which we think it's important our help need to be there. And any other legal matter that relates to immigration law, we represent in our firm. So any assistance you need personally, feel free to reach us anytime. I'm one message away or one phone call away. You can always reach me, and I should be able to assist you all. Thank you very much for giving this opportunity.
Yeah. We got another our guest speaker. Sai Manthra is a local attorney of Arizona, and he's a founder of the Manthra Legal Counsel, and he's been practicing over 19 years. So he's known for his immigration law in Arizona. So Sai Manthra Garu, can you please introduce yourself?
Yes, this is Sai Mantra, and I am from Arizona, like Vasu said, and I want to thank you, thanks TTA, Naveen Garu, Mallareddy Garu, Praveen Samala, and Jyoti Reddy Garu for giving us this opportunity to answer questions. I actually am practicing law for about 6 years now, but I've been in this immigration stuff since I got to the US. I also practice criminal law. So what I do is crimmigration, mostly with trying to stop people from getting deported or not being able to get admitted into the United States. So I actually practice in the intersection of both immigration law and criminal law. If anyone has any questions with regards to deportation, removal, criminal defense, or immigration law that's related to crime, feel free to reach me. Thank you, Vasu.
Yes. So let's start into our webinar today. So in today's webinar, we are going to discuss about what are the we are going to understand the immigration changes, what the Trump administration brought it, what are the new rules, H-1B, modernization we have, FN student issues, birthright citizenship, Lake and Raleigh Act and implications, and other immigration issues, what do we have. So let's start with our Q&A. Yeah. So, Bhanu Garu, you would like to start on the things what you want to start with the H-1B modernization rules. so that we'll start some questions. What are the as per the coming questions, I will be asking you.
Sure, definitely. Thanks, Vasavi. And I think it's the time of the hour discussion with H-1B modernization rule. The new changes to the H-1B program can play a significant role for our community. ఆ మార్పులు చాలా చాలా issues can rise up in our running of businesses and everything. Biden, while leaving, they passed this new regulations called H-1B modernization rule on December 17th, and that regulations came into effect from January 17, 2025, making changes to the H-1B program entirely, especially about the evidentiary aspect of the H-1B program, what documents are needed to be provided and what evidence needs to be provided, and also how do you determine whether a position qualifies as a specialty occupation for H-1B purposes. So that is very important changes for the H-1B moderation program. However, before going to the H-1B moderation rules, now most important thing is the cap season is coming up for the H-1B program. We all know that H-1B is oversubscribed every year. So the USCIS requires us to register for the H-1B visas in the month of March every year. And this year, the registration starts on March 7, 2025 and ends on March 24, 2025, noontime Eastern Time. It also starts on noontime Eastern Time, March 7, 2025, where you're required to submit the registrations on behalf of the beneficiary by an employer by paying $215 per each beneficiary. Previous years, it was $10, but from this year, the registration fee has been increased to $215 per beneficiary. It's very, very important that all the employers take a note of this and make a proper fee payment and submit a proper registration so that they won't lose an opportunity sponsoring H-1B visas in this coming fiscal year. And the fiscal year filings will start from April 1, 2025 and ends on June 30th, 2025 for the cases that have been selected in the lottery registration. So that has not been changed much except the fees. Nothing much has been changed. Everything else has remained the same. You have to submit the minimal information about the beneficiary and the employer for the purpose of submitting for the registration. But if it comes to H-1B modernization rules, they have actually discussed more about the eligibility for the H-1B and who can file an H-1B petition, who qualifies for an H-1B petition, and how we can determine H-1B as a specialty occupation, and also increasing the gap for the F1 students also at the time, and also making site visits for the compliance review by the USCIS and other agencies, and to participate in those site visits as mandatory for the employers and the employees. These are the major things which are been implemented with H-1B moderation rules. Why it is so important is I think many of the H-1B community is aware that in 2020, ITSF Alliance, another non-profit organization, was able to file a lawsuit against the USCIS about the neutral memo requirements, where they arbitrarily required every employer to provide project documentation like client letters, client agreements, and MSS to show that there was a bona fide job offer exists for the employee, and there is a valid employer-employee relationship exists between the employer who's sponsoring H-1B and the employee who's actually going to work for them in this particular position. And in ITSF Alliance won that case against the USCIS, therefore the memo was rescinded, and there was no itinerary requirement also. So therefore, there were no longer short-term approvals were issued by the USCIS also, because we used to see a lot of short-term approvals also prior to 2020 by the USCIS. All those things have been changed from 2020, and we are getting H-1B approvals very easily. It has become very easy for the employers to file an H-1B petition as long as they can show they're a bona fide US entity and they have a requirement for the beneficiary in H-1B petition based upon the nature of their business, and they're able to get H-1B approvals and able to do their business and continue to do their business and everything. Now, again, that changed with this H-1B moderation rule. Again, with this H-1B moderation rule regulations, now we are going back to prior to 2020, where we are required to provide, especially if it's a consulting services business like IT consulting services or healthcare consulting services, where you're required to provide and where your employees predominantly provide services for third-party companies, then you're required to provide all the contracts or purchase orders or work orders or client letters or any other documents that can substantiate your contractual relationship among all the entities involved in between, for the purpose of showing valid employer-employee relationship exists between you and the employee for whom you're sponsoring an H-1B petition. So those things are become mandatory right now. And also the requirement is that at the time of filing, the employer must have a bona fide job offer from the requested validity date of that petition. That's what the new regulation says. So, and USCIS did not provide any clarification what do you mean by bona fide job offer. But very strongly, if you look into the commentary section of the regulations, what USCIS intended is non-speculative employment. Now, speculative employment is okay. Until January 17th, speculative employment is okay if you want to hire somebody on H-1B, but it seems like US is going back. They're indirectly implementing non-speculative employment, even though the regulation do not state non-speculative requirement of an H-1B program. So these are very, very important because now there are a lot of prospect H-1B individuals are there in the country who are being on F1 status like a STEM OPT or OPT or H4 visa holders who wants to get an H-1B visa so they can continue to work with their employers. Now they have to understand that they have to go through those musters to get an H-1B petition from the employer. And it is not impossible, it is possible, because it's not necessary that you have to provide only contracts, but there are alternative documents you can provide also. But these are the things which we have to require to provide to get an H-1B approvals. It has been done in the past for 10 years, and we can still continue to do that with the H-1B program. And also, they change the requirements. There are a lot of technical issues out there which we can discuss in detail about the H-1B moderation rule. But simply is, you have to keep it in mind that this is what they're really looking into. They're asking you exactly what you have to consider in filing an H-1B petitions and everything. And other thing also is, Praveen, I want to ask you, do you want me to go in detail about the H-1B moderation rule, or just giving an outline like this should be enough?
Yeah,
Maybe a little deeper, meaning like maybe another 5 to 6 minutes would help our audiences.
Okay.
So, yeah.
Yeah, that's what I thought. Yeah.
Okay, thank you very much. Yeah. See, if you're predominantly in a business as an employer, okay, in providing services where your employees provide services to third-party companies, whether remotely or at their location, then they're saying that in this H-1B moderation rule, especially if the employee provides services to the third-party client side, and if the employee fills the position in the third-party company in their organizational hierarchy, okay, and becomes a part of their organizational hierarchy by filling that position, then the requirements is not your company's requirements for purpose of showing whether the position qualifies as a specialty occupation. What they're saying that is, if he becomes a part of the organizational hierarchy and providing services as a part of the organizational hierarchy, then the requirements of the end client is important to determine whether the position qualifies as a specialty occupation or not. That means if any H-1B petition filed by the consulting company and if the third-party company providing services, they're going to look into the requirements of the third-party company to determine whether the position for which employer is filing for you qualifies as a specialty occupation or not. There are many issues will come up with this. One is if most of the clients do not mention what are the educational requirements for the positions for which they're hiring you.
Okay, we didn't miss anything, right? We didn't take out anything. So,
I'm sorry? So sometimes, sorry,
Mute is on.
Is it possible to mute from your end? Having some kind of inconvenience here, I'm sorry for that. And sorry, I lost it. It's very important for us to understand that if the end client does not require an education and you want bachelor's degree at a minimum because the position requires in order to be considered something as a specialty occupation, the position should require at a minimum bachelor's degree or its equivalent in a specific specialty in which employer intends to employ someone in the particular field of endeavor. Okay, so if you require a bachelor's degree or at a minimum, but if the end client does not require a bachelor's degree, then USAs can come back and tell you that this position may not qualify as a specialty occupation, therefore you may not be eligible for the H-1B petition. So the most important thing here is we have to make sure that employers should be able to establish that in these circumstances that the employee is just providing services for a third-party company, but not as a part of their organizational hierarchy, or is not filling any position in their organizational hierarchy. He's just an independent contractor and is providing services through on behalf of your company, and your company is responsible to actually or supervise or manage or control the work of the beneficiary. If you can establish that, then you don't have to go through that requirement. That's what I want to tell you. A lot of people are getting confused with this particular requirement. I really want to provide clarification on this requirement based on the language in the regulations. And also now, based upon these H-1B moderation rules, now there's a possibility that we may get a short-term approvals by the USCIS. But they said that if they give a short-term approval, they're going to provide an explanation in a page why they felt like a short-term approval is needed in these regulations. Even though in the comments and summary, in the proposed regulations in the beginning, NPRM, they said that they're not going to do short-term approvals and everything, but in the final regulations, they actually tweaked it and they inserted that where they said that they're going to give a short-term approvals on these H-1B petitions. So that is these are the things which we have to keep it in mind with this H-1B program, H-1B moderation rule. And most important thing, besides all these things, most of this will be handled and helped by your attorneys who are preparing your cases, filing your cases. They'll be able to guide you and properly prepare the cases and properly present your arguments before the USCIS. But only things attorneys may not be able to control is your own actions during the site visits. If you try to take on your own in your hands during the site visits what you wanted to do, then attorneys cannot control you over there. And whatever you say during the site visits, మీరు site visits లో ఏం చెప్తారో దాన్ని బట్టి మీ యొక్క H-1B అవుట్కమ్ డిపెండ్ అయి ఉంటుంది. ఆల్రెడీ అప్రూవ్ అయిన H-1Bని వాళ్ళు రివోక్ చేయొచ్చు, లేదా H-1B అప్రూవ్ కాకపోతే ఆ H-1B డిలే చేయొచ్చు.
Bhanu, don't mind. Not everyone is Telugu here. Like,
Okay.
Tamil also joined here.
No, because I was asked to speak.
Bhanu Garu, there was a question. What happens when an attorney, when the USIC...
Vasavi, can you hold off, please? Let's take questions at the end before closing the webinar. Not now. Okay? Please hold off and I'll take care of Q&A. So, Bhanu Garu, sorry to interrupt you. Please go ahead.
No, that's okay. I'm very happy to speak in English, Praveen. And,
yeah, that's okay. Yeah, you please go ahead.
And so it's very important for us to understand that it's... So during the site visits, it's very, very important for you all, just be prepared that you're going to get a site visit for any H-1B petition you file in your company. If anybody who's seeking an H-1B petition, they need to be prepared psychologically that they are going to get a site visit compliance review, and they should be prepared on how to handle that competently. It's very, very important. The best thing is under the circumstances is because it's a mandatory participation, if you don't participate, then they may use that against you for the denial or revocation of an H-1B petition. Same with the employer and also as the employee as well. So the important thing for the employer and employee is how to handle the situation as smoothly as possible so that it won't jeopardize their H-1B petitions. So the best thing is for the employer and the employee to tell to the officer when somebody comes into the office or somebody sends an email or makes a phone call saying that you're very happy to answer all the questions what they want, but through your attorney. If you do not have an attorney on the file, just let them know that your attorney will be able to your attorney will be able to get back to him and provide all the details so that the officer can provide all the information required and they will be able to answer through that. Same thing your employees also should say. I think as an employer, it's very, very important for you all to basically provide this kind of orientation sessions with your employees where you educate your employees what to say, what not to say, and how to behave when FDNS officers comes into their home or into their office wherever they are working, not to give any information that is not true or incorrect, because that can jeopardize their immigration future also in this country, especially during the Trump administration, where they're going aggressively on enforcement policies. I think it's a good idea to be careful not to answer anything which you are not aware of, or just to try to cover it because my husband has said something like this, my husband friend has said something like this, my uncle has said something like this. Those things are really bad thing to do. Your uncle is not an immigration attorney. Your husband is not an immigration attorney. Your husband's friend is not an immigration attorney. Or your wife's friend is not an immigration attorney, or your wife is an immigration attorney. Just do not take opinions of immigration law from your friends and relatives or your best wishers or well wishers. I don't think they have any bad intention, but they're not experts. They're not capable of giving you proper legal advice. They can only tell you what their experience was, and sometimes their experience is also what their imaginary circumstances were. They're not true also. So just don't get into trouble because of that. It's very, very important, especially during site visits. You can put the burden on your attorneys because your attorneys are getting paid for that anyway. Just let them know that your attorneys will get back to you and will talk to you. If you have a G28 of your attorney in your hand, it's well and good. You can give the G28 to the officer if the officer comes in person. If not, let the officer know that your attorney going to reach out to you, and if required, they're going to provide the G28 and everything to them. Officer will not say no to it because it's your right given by the Constitution, a right to an attorney to represent in immigration matters or any administrative matters or criminal matters in this country. So keep that in mind with the FDNS site visits because it's very, very important to be in compliance and to be cooperative and to be important to provide information, but do not speak unnecessarily, do not get panicked, do not get nervous, and don't try to be a good Samaritan. Don't think that because officers talking nicely to you or sweet to you, don't think that he's your friend, he's going to be nice with you, he's going to do right things for you. No. His job is to find fraud with the immigration petition. His job is to find problems with the immigration petition. That is his job. That has been he's getting paid for. And that has been the reason why he has been hired for. So these things you have to keep it in mind with the FDNS site visits. So just be careful. This is very, very important topic. I think a lot of people will have questions over here during Q&A, and I will be very glad to answer in more detail here also. With the H-1Bs also, right? And how to define a specialty occupation, the 4-point criteria, how do we meet those 4-point criteria? Those things are very technical in nature. As I said, this call, I don't know how many people will understand that technical nature of that explanation over here. That's why I'm skipping that part over here. I'm just going on the outlines with this H-1B moderation rule here. And other thing also you have to understand this H-1B moderation rule also clearly requires an employers when they file for an amendment of status or extension of status to show the maintenance of status of an individual who's in this country already working for them on H-1B visa. How we can show the maintenance of status for them? By pay stubs, W-2s, work orders, tax returns, quarterly wage reports. There are so many other documentations you can show that somebody is maintaining valid legal status in this country at the time of you seeking an amendment or extension of status. And the regulations for filing an amendment of status has not changed in the H-1B moderation rule. Still, matter of CMO Solutions Memorandum and its policy governs when to file an amendment. That means whenever there is a material change occurs, the material change is if somebody change in job responsibility is so significant that it is considered material change. That means more than 50% of the job responsibilities have changed than what it has been stated in H-1B petition, then there is a material change. And if the nature of the job also changed, for example, if the nature of the job is, for instance, if the individual is working from the office and suddenly it becomes different shift or multi-shift position, then the nature of the job also changes. Those are the facts which you have to look into and discuss with your attorneys when you're required to file an amendments and everything. And third thing is this: if you move outside the location of the intended area of employment in LCA and in H-1B petition, then you're required to file an amendment. The requirement is that if you move outside the commutable distance of the intended work location that is stated in LCA or in H-1B petition, then you're required to file an amendment to an H-1B petition. Many people get into trouble over here. They try to save few bucks here, like $800, $1,000, $1,500, $2,000, whatever it is. To save the $2,000, they violate their status. They take entire risk with their immigration status. I don't understand that psychology. I don't understand the logic behind that. it is something which I strongly discourage such kind of a behavior because it is not required. File an amendment timely so that you don't have any issues with the maintenance of your status and everything. Then you will not face any problems when you go for the stamping in the future and entering into this country. Those are very, very important things. And also, USC has clearly said that in these regulations that if H-1B extension of status and H-1B amendment of status approval is discretionary, and if they deny those statuses, extensions or amendments, you cannot appeal anymore. Previously, you'll be able to appeal if any extension of status is denied or amendment of status is denied or H-1B petition is denied, except change of status. You should be able to appeal to the US. You should be able to appeal that denial with the AAO and other agencies. But right now, you cannot appeal anymore for extension of status or amendments. You can only file for motion to reopen or reconsider if any H-1B extension of status or amendment is denied. And I think we have other topics to cover also. I think that's why I'm just summarizing here. I'm leaving it here.
Yeah, thank you, Bhanu garu, for giving a very valuable information. I think some of maybe the questions maybe come at by the end of the webinar, but it was a great session. And Sai Manthra garu, can you please give the intro about the starting telling about the birthright? I know everyone has many questions on birthright citizenship and Lack and Relay Act and about other immigration issues. So that.
Yes. Thank you, Vasar garu. So with I'll start with Lake and Riley Act, and then and I'll then go into the birthright citizenship. So the way I want to present this Lake and Riley is kind of put it instead of I want to kind of put it more like what you should not be worried about versus what you should be worried about. A lot of people I know are worried about this Lake and Riley because it comes out with being able to detain people. Now, the first thing in this, there are two parts to this act. The first part of this act is they cannot detain people that are already admitted here. People that are in a legal status, this act doesn't apply to them. It doesn't apply to people that are deportable. The only people it applies to is for people that are inadmissible. So the key difference here between deportability and inadmissibility are two different things. So what is deportability? If you're already inside the door and I ask you to leave, that means I'm deporting you. But if you're at the door knocking on the door and I say don't come in, that's inadmissibility. Now, how does this work with people that are inadmissible that are already in the United States? So when people come either on an asylum request or a refugee request, or sometimes they, whatever reason that may be, if they get paroled, even though they are inadmissible, as long as they are here, they can still be in the United States waiting for their removal, and this act only applies to them. Now, is it anything new? What this act really did was kind of close some gaps. So what are the people? What are the types of inadmissible people that can be deported under this act? Anyone that's committing burglary, theft, larceny, shoplifting, assault of an officer, or committing a crime that results in death or serious bodily injury. Now, this serious bodily injury is a felony, aggravated felony in most states anyways. An assault, aggravated assault is a felony in most states anyways, and it's automatically deportable and inadmissible at the same time. Same thing with death, which is a murder. Assaulting a law enforcement officer is actually not within the federal statute as one of the aggravated felonies, so that's where they close the gap. But most states, if you assault a law enforcement officer, it is a felony. Now, why am I talking about why we should not be worried about? I don't think the people that we have in this group are going to do any one of these things. But be careful though. Like I actually worked on a few cases around here where people were actually there is a class of people are different, and in their culture, if they are angry at somebody, the way they express their anger is by spitting on the other person. So I have actually worked on cases where people were spitting on officers, and next thing you know is they have been booked for aggravated assault. You get arrested and they put handcuffs on you. Even if you wiggle a little bit and you touch the officer, he could come back and call it for an aggravated assault. So what this is doing, assault on a law enforcement officer, is simply just closing that gap. Most states, like I said, already have it on their books as a felony. Any felony pretty much is deportable or inadmissible. That's because most states have a felony. The minimum punishment for a felony is at least 1 year. Now, that leaves us with the burglary, theft, larceny, and shoplifting. I do work on several cases that come from our community. I think it's lack of information. And also now retail stores have gotten very stringent on how they watch people. So shoplifting is a petty offense. It was not one of the things that would make you inadmissible. However, with this new law, even something like a shoplifting, uh, stealing a toilet paper during COVID could also become become a problem for people. It could lead to grave consequences. Now, does this act go retroactively, as in going behind? It doesn't actually go behind. All it does is, okay, so if a person is inadmissible and they are found with one of these offenses, then absolutely they can be removed. Or if a person already has charges filed against them and then they become inadmissible, they could also face consequences. But it doesn't go retroactively in the sense that someone is convicted 3 years ago for a shoplifting or a burglary. It may not apply as of today. Now, what are we talking about today? This act came into effect on January 29th. So it's already in effect as we speak. But the good news is, the stats actually show that only a very small fraction of people are affected by this. So I don't think we have anybody in this group that need to be worried about it. And that being said, now I want to move on to the next topic, which is the birthright citizenship. So President Trump, one of the first executive orders that he signed was taking away the birthright citizenship from it goes two ways. It talks about females and it also talks about males. When it comes to males, it simply says as long as the father, a biological father, is not an LPR, legal permanent resident, or a citizen, and the mother is here on a temporary visa, or if she is staying here um, uh, without proper documentation, just because they are present here, or the children that are born to them do not get birthright citizenship, is what what that order meant. Now, the 14th Amendment of the Constitution does talk about anyone that's born or naturalized in the United States are citizens of the United States. However, they have to be subject to the jurisdiction. So this entire order is based upon that one word, which is jurisdiction. This particular executive order has a preliminary injunction. If not, it would have come into effect on the 19th of this month. But right now, there are preliminary injunctions. There was a preliminary injunction that was given to this today, which effectively stalls this order to come into effect, at least until some of the lawsuits are resolved. So the previous preliminary injunctions were for a temporary period of time, but this one also being a temporary period of time, it has to wait. The order has to wait until the other lawsuits are resolved. But the question now turns around. Now, do these courts actually find that someone that's here on this soil, are they automatically under the jurisdiction or not? Now, this jurisdiction is a complicated thing. Under the due process, anybody that's on this soil automatically is under the jurisdiction of the United States. But then again, for different other things, that jurisdiction changes, like domicile and those types of things. I think the executive order kind of is trying to leverage some of that language, but we have to see how the courts decide whether there is the jurisdiction part of it, how that fares. Is someone that's born already here, are they under the jurisdiction or not? We'll have to see how the courts decide that. So that's all I have to say.
I'm just adding. Thanks, Sai. That's a great information. I just want to add a couple of things to what Sai said here about both the topics, birthright citizenship and also with the Lake and Riley Act. See, the problem with I think as Sai said, not many people might not have been impacted with this particular thing. But you have to understand this. The act clearly says that illegal non-US nationals. Okay. What does it mean is that if somebody, even though they entered legally into this country, and if they violate their status, if they're in violation of their status in this country, like for example, if somebody enters on a B1, B2 visa and overstays in this country, or somebody comes on H4 visa, overstays in this country, and if they commit a crime of petty theft, like a theft or shoplifting or anything, then they may be subject to the removal proceedings, deportation, as per the Lake and Riley Act. Okay, and the subject matter in this is that the amount threshold is very low in this Lake and Riley Act. It's only $100. In many jurisdictions, misdemeanors for petty theft exceptions will be around $500, $750, $950. For instance, in Texas, it's $950. In California, it is $750. In many other states like Virginia and everything, it's $500. So you have to keep it in mind that make sure you check if you enter legally into this country, make sure that you're maintaining valid legal status all the time, not to be subject yourself unnecessarily to the deportations or removal proceedings because of this Lake and Riley Act. Most of the times, why I'm telling you this is, we get every day at least 5 to 6 calls, people saying that they did not check their I-94 online when they entered into this country and their I-94 expired because they issued the I-94 as per their passport validity date, because passport has a lesser validity date than their actual non-immigrant notice approval validity date. So just be careful with it. Every one of you, make it a practice. Kindly make it a practice. Kindly make it a practice to go back to I-94 website, pull out your I-94, make sure that everything information is proper in that I-94 or not, and ensure that you print that copy of it and keep it with your passport. Because under last action rule, whichever the latest I-94 is issued to you, that governs your status. So these are the things which you have to keep it in mind. The reason why I'm saying is this: one small negligence or a lazy act can get you into legal trouble unnecessarily, which is not required, right? Because these are very simple things which you can take care of. If it comes to birthright citizenship, as Sai said, one thing I want to tell you is today there was a new restraining order came, which is applicable to the ban on the executive order implementation nationwide by the Maryland District Court. And the District Court judge clearly said that today that this cannot be implemented because it's likely that the aggrieved parties, that the aggrieved parties are the plaintiffs, which are 5 pregnant women and several other non-profit organizations which filed this case, said that it's very likely that they might win this case under the constitutional grounds. Therefore, they're issuing the restraining order to implement this EO across the nation, just not in the court jurisdictions where the court has a jurisdiction, which previous restraining orders have been done in the past in 22 jurisdictions. But now with the Maryland restraining order, now it's applicable to all the country. Until these cases is decided, it's very difficult for them to implement these policies. But you have to understand there's always a caveat. These administrative agencies can create a problem for you in issuing your birth certificates or issuing your social security numbers or issuing your passports and everything. Any such issues happens, do let us know as an attorneys. We'll be able to work on them very actively and make sure that those things will not happen while this case is pending and everything. And of course, the current administration is banking to take this case to Supreme Court. I think that's what, in the end, this birthright citizenship will happen.
Thank you, Sai Garu and Bhanu Garu, for your valuable information. I think it helped many of the people. Yeah, we have so many of questions, but I think so many of them are got cleared. So, so guys, we are opening our Q&A.
We did not talk about anything about the F1 students. It's very, very important to talk about them.
So
I would take 5 minutes. I will take 5 minutes on that because lots of students are here, I think, today in the call. And it's very, very important for them to understand the importance. First thing is F1 students who are in this country, okay, and they have to make sure that what type of program they're getting admitted into, whether it's regular full-time program or if it's a hybrid program, okay? And if it's a hybrid program, how that hybrid program is run by the schools is very, very important for them to understand that. And Also make sure that the school which is admitting you into the hybrid program, do they have that from service authorization, that they can have actually enroll somebody, foreign students, by issuing an I-20 into the hybrid program. If not, these can result in violation of your status, and they may lose every benefit you can seek as an F1 student in this country. Because this has happened recently with certain universities, and we have seen several RFs coming into them, and we're addressing them. Fortunately, some of those universities do have a designations or the authority or a authorization from the service to get admitted to the hybrid programs, to run the hybrid program in a particular field of endeavor, which they wanted to admit these students, but the USS doesn't have that record. So it's very important for us as a students, you take a note of that. When you're taking an admission to any program, you take a note of that, what kind of a program you're getting admitted into, whether it's a regular full-time program or a hybrid program, and what are the requirements to comply with those requirements, so that you will be considered as a full-time student, which is required to maintain valid legal F1 status in this country. And if it comes to your OPT and a STEM OPT, make sure that what kind of an offer letter is your employer giving you for the purpose of seeking an OPT authorization from the school. And also, many students have a misapprehension saying that they can aggregate the number of days of unemployment for the STEM OPT and OPT. It is incorrect. They cannot aggregate that. They can only be unemployed up to 90 days in the initial OPT and 60 days in the STEM OPT. They cannot aggregate of 150 days unemployment either in initial OPT or in the STEM OPT. Regulations clearly says that one person cannot be unemployed more than 90 days in initial OPT and not more than 60 days in the STEM OPT. And initial OPT can be paid or unpaid, but the program has to be genuine and bona fide if it is an unpaid internship as an initial OPT. And make sure all the documentation is properly given to you. You keep in touch with your employer all the time. Just get a letter, give it to him, and then forget about it and do whatever you want to do. That's not the way it works. You should not do those things. It's very, very important for you to maintain valid legal status in this country. If you think of pursuing your American dream, that's very, very important as an F1 students, and that's one thing which you have to keep it in mind. And during the STEM OPT also, you are mandatorily required to be in a paid employment, and the minimum paid employment must be 20 hours per week in a STEM OPT. And also, you're mandatorily required to provide your evaluation forms also, periodical evaluation forms also from your employer, exactly what you have done, how is your programming being done, and all those things, and must be submitted to the school, and so that school can update all this information. And also, if any changes to your employment or the nature of the job, what you're doing, it's important to notify your school, and school will update in your service record and everything. These are the things which I see students are very, I'm not sure whether they're ignorant or they're lazy or they just don't care about it, but I've seen lots of students getting into trouble these situations, and that's where their status violation comes into existence. That's how they lose their F1 benefits and they become out of status in this country. So it's it's very important for them to make sure this information is needed. If they don't have this information, we're very happy to provide such information to them. They're very happy to feel free to reach our office. We do weekly conference calls in our firm. I do weekly conference call every Tuesday. Join our calls, and we have a WhatsApp groups for our firm. You can join our WhatsApp groups. There are thousands of people out there in those WhatsApp groups. They will be able to answer you questions and everything. We have more than 20 groups for our firm in WhatsApp, where we daily monitor. We try to provide as much guidance as possible in those WhatsApp groups. And you're welcome to join if you want to join in those WhatsApp groups and everything. But my point is, make sure that you comply with the regulations very, very carefully. For example, if you take 2 jobs during your OPT, whether initial OPT or a STEM OPT, it is important that you inform that to the school and obtain your I-20, update your I-20 accordingly, get a new I-20 accordingly, showing both employers' names as your employers. And if you don't, that can result in violation of your status because you worked unauthorized. So keep that in mind. And initial OPT employees can get paid on 1099 depending upon what kind of a job they're doing, how they're doing, and everything. But if you're in STEM OPT, you cannot get paid on 1099. you have to be a W-2 employee. And so those are the things which you have to keep it in mind. And F1 students, a lot of F1 students come and ask me, sir, I have this plan, I have this product, I have this venture capitalist coming for me. Can I start up my own entity? Answer is yes, you can. But you need to have some other principal with you so that they can actually, especially if you're in STEM OPT, you need to have another principal with you who can actually evaluate your performance and be your trainee in that particular program. So yes, you can be an entrepreneur, you can start up your own entity, and you can get your own funding, you can start your own ventures if you can. But don't try to do a business where you have to sponsor immigration or any immigration visas or anything like that to them, because that can result in a different thread and vibes, because they may think that you are trying to trafficking the humans in this country. Sometimes they can go to that level also, depending upon what kind of information they can find when they do the investigation on it. These are the simple points which I want to tell to the F1 students here.
Bhanu garu,
Yeah.
Bhanu garu, for the good of the group, can you explain to them if they do a voluntary internship without payment, is that allowed, and what kind of employers can they do that voluntary internship with?
If it's only in the initial OPT employment, then they can do there is no voluntary, it's an unpaid internship.
Unpaid internship, yeah.
There is no voluntary here. The volunteers,
unpaid, yeah.
There is no voluntary here. Volunteership is entirely different from being an unpaid internship. H4s cannot do volunteer for the for-profit companies, or F1s cannot do volunteer for the for-profit entities. The volunteership only comes for the non-profit entities, and also in a certain service activity only. If they're involved into certain activity, then they can be a volunteers into the service activities. So it's very, very difficult, very, very important to identify what is volunteering and what is a unpaid internship is. You are performing a duty or a responsibility as an unpaid intern, which is a part of your training in the field of endeavor in which you're graduating or you graduated already. So it's very, very important. There's no volunteering in F1 OPT or STEM OPT. It's always, you can be unpaid intern or unpaid intern in the initial OPT.
That unpaid intern can still be an unpaid intern for profitable companies, right?
Yes, for profit company, but the for-profit company has to have a bona fide program of unpaid internship in the company. That means they're not just giving unpaid internships just only for the OPT students, but across the country, for all the students in the country, US students, everyone. They should not bias, they should not treat unfairly, only provide such unpaid internships only for their F1 students. And they have to properly publish about their program. They have to disclose about their unpaid internships programs, these employers, and they have to make a note of that properly. And it should be published exactly in the schools, in their websites, in their programs. They should have a well-established unpaid internship program in their company.
Also, I wanted to add a couple of 2-3 points for the H1 highlight level points, which are outside of what we were talking about earlier. They changed the rules for nonprofits from a primary mission to a fundamental purpose. So for a nonprofit, which means even not for profit can also, as long as there is a fundamental purpose, there is no cap requirement for H1s. That's one of the.
That is, I respectfully disagree on that. They have to be a nonprofit, or they have to be affiliated to a nonprofit. The individual must be providing service to the nonprofit entity, where their fundamental purpose is involving in such a research activity.
But there is also the 50%, requirement that they have in there.
That's what I'm saying, sir. That's what I'm saying, sir. A for-profit entity cannot have a cap-exempt employee unless the cap-exempt employee is providing.
No. I was only talking about not for-profit, not non-profit, because there is the 50% requirement. And then the other thing I wanted to also some of the cases that I've seen is there were a lot of rejections, denials for people that had prior approvals of H1B, but then they were denied for the same position and the same employer, nothing changes. IT Serve Alliance has actually fought against it. But now what they're doing is, one of the good things about this modernization is it is asking, unless there is a material change, for the officer to look at prior determination for extensions and amendments. So if they have decided a certain way in the past, unless there is a material change, they are asking for a difference. Go back and look at it, and if you've approved it in the past, do it again. So that's one good thing that
Yes.
this
Unless there is a gross error or
a material
change in the petition. But point here is this: it has always been there. It has always been there in the previous policy memorandums and everything. If you look into it, the USCS always requests the officers to look into the prior approvals, because while we are filing cases, we do cite them as an examples when we're filing an extensions or anything like that. And that's how we try to present it to the USCS all the time. It's always been there. They reiterated the same policy in the new regulation too.
The only difference is before IT Serve Alliance actually fought it 3-4 years ago, they were just simply denying it. And
they were denying it. They were denying it for the purpose of showing that employer failed to show the right to control of an employee's employment, and also to show that whether there is any valid bona fide job offer exists in the specialty occupation or not. The issue is about the right to control when the employee is working at the third-party client side. Especially in California Service Center, there has been a huge issue prior to IT surveillance case, and that's where the whole issue is. That's what they were basing their denials on the Neufeld memo, and the Neufeld memo is based upon the Fifth Circuit Court case, which is a Defensa versus Meisner, where it clearly says that case law says that the requirements must be based upon the requirements of the position must be determined upon actually who the entity actually receiving the services of an employee, and right. Based upon that, they can determine the factor control, who's actually controlling the employment of the beneficiary. If the requirements of the end client meets the requirements for specialty occupation, and if they can establish that they're actually controlling the work of the employee, then they're entitled to for the approval. That's what the Defensa versus Meisner is. That's what the Neufeld memo is actually trying to reiterating the policy. Even these regulations also.
But even with the memo, they were arbitrarily denying without the right of control issues also.
You can expect that to happen. See, that's what it is.
That's true. Yeah, we can expect that to happen now also. And one other thing also that I wanted to add with regards to the contracts, one thing that did not come back is, even though now they might ask for contracts, they're not really asking for terms and conditions. What they're focusing on the skill sets and duties is what the new regulation is.
No, not really though. I mean, see, that's the whole problem, right? That's what they're claiming in the summary in the comment section. But if you look into the regulatory language, it doesn't say anything like that.
It is actually in the regulatory language.
In the regulatory language, it doesn't say anything. Go through the regulations, it doesn't say anything like that. What they're looking for the contracts and everything. It only says that it requires, you can provide contracts, work orders, and other documents for the purpose of showing valid employer-employee relationship exists, for bona fide job offer exists. But it doesn't say that they're not looking into the terms and conditions in the regulatory language. In the commentary sections and in the summary sections, whatever you call them, in the preamble, they talk about that. Very important to go through the regulations.
Yeah, and I beg to differ on that, but it's okay. The regulations are regulations. We'll see as time goes on how these rules work. That being said, one other thing I also wanted to talk about when you talked about these employer site visits, the most important thing that I see that employers do is that when there is an LCA or documents that we send you and we ask you to display it on your notice board, on your bulletin board for 10 days so that everybody can see, a lot of employers that we see, they don't actually post them. And we send them the entire file, and they just save it. We ask them to create a file, put everything, the LCA, the H-1B approvals, your job duties, all of that in a file, and we ask them to put it in a file, and then there are certain requirements of displaying on the bulletin board. A lot of employers don't do that. And I ask employers to consistently, diligently do it, only because now that they have the authority to conduct site visits, if they show up at a site visit and what is supposed to be displayed, they don't see it, it could create troubles or problems.
That's a very good point, Sai. But point here is this: the LCA must be posted on or a day before the individual starts performing services at the work location for 10 business days, at the work location where the beneficiary is working, not at the company's location. If the company's location is the work location, then it is be posted at the company location for 10 business days. But if the employee's work location is his home or at the client location, then it has to be posted for 10 business days. Usually that comes in the LCA posting notice violation requirements, and usually Department of Labor is more concerned about it rather than the USCIS on that.
Yes.
Okay. That's the reason why I did not talk about that, because we are not talking about the Department of Labor regulation here. We are only particularly emphasizing what are the issues that have been stated in the H-1B moderation rule. What are the significant changes that H-1B moderation rule has brought into this? That's why we are focusing on those issues here. That's the reason why I went on a summary on a very outlining basis over here, because it's impossible for us. If I can talk 4 hours on the H-1B moderation rule, even one day whole thing, because if I have to go through regulations, each and everything, I can go one day whole thing.
Well, thank you, Sai Garu and Bhanu Garu. It was a great discussion that we have came across so many, rules and regulations and more information, and the good things, Sai Garu, that you have raised about LCA. Yes. So let's, do you want to address anything on H4EAD? Because there were many questions are asking about H4EAD. So after that, we can start the Q&As.
Whom do you want to answer this, me or Sai?
That's up to you guys.
Okay.
Because there were so many were requesting you personally
or do you want to
about
go on
H4EAD, so that's why.
Sai, do you want me to go on this, or do you want me to? You're on mute, Sai.
Oh,
do you want me to go?
Yes, sir. Please go ahead.
Thank you, Sai. I really appreciate it. And see, as of today, there is no change in with H4EADs. Okay, and people are eligible to apply for H4EADs as long as they meet the requirements for the H4EAD. Okay, what happens in the future, nobody knows. Okay, see, the point here is this: we just can't plan our future that something is going to come and hit us. Okay, I mean, it is not appropriate way of thinking. Unnecessarily, it gives you unnecessary stress. It impacts your health and everything. If you're worrying that when you're walking on the road, something is going and come and hit you, but you have to walk on the road to go to somewhere else, right? So there's no point in worrying what may happen in the future and everything. As of today, there are no issues with H4EADs or H4s. They are eligible to apply for H4. If they're eligible to apply for H4EADs, they can apply for H4EADs. And a lot of people don't know for H4EADs, they think that in order to be eligible for H4EAD, they should have a I-140 approval for their H-1B spouse. They only think about that. Actually, it's incorrect. If the H-1B spouse is eligible for 7th-year extension based upon AC-21 Act 106A and 106A and B, and also under Section 104C of AC-21 Act, that means if somebody is eligible for 7th-year extension based on pending labor certification for 365 days or I-140 pending for 365 days, then the spouse is eligible for H4EAD also. Okay, a lot of people don't know that. A lot of people only think that one is eligible for H4EAD only if the spouse has an approved I-140 approval. That is only the thing which I want to bring awareness to the people here during this call, saying that do not miss your opportunity to apply for H4EAD. If you have an opportunity to apply, if your husbands or your spouses, your wives, whoever it is, their labor certification or I-140 is pending at least for 365 days and waiting for the adjudication of it.
Well, thank you, Bhanu Garu, for addressing the H4EADs. Thank you for your. So please, we are opening our slots for Q&As, and you can post your questions.
I think we have received a lot of questions already, and thanks, Vasavi, for your proactiveness, and let me take it over from here. So so far, we have received 21 questions. We'll just go by order in the interest of time. So first question was asked by Partha Saradi. So the question is, I think it's either of you can compliment and talk about it, or maybe whoever can take it up, maybe just between Sai, Manthra, and Bhanu, Ilindra. So just raise your hand so that you can take it over. So the first question from Partha Saradi is, we are expecting our kid in March 1st week. Will this Trump execution order will impact getting SSN number, birth certificate, and passport? If yes, how we will apply India passport from US, and what status will have the kid till he gets the passport? So yeah, please, Sai, go ahead.
Yeah. So for now, there is an injunction and the restraining order, but until that's lifted, the executive order is actually not in place, which means the executive order is simply a mandate to all of the government agencies saying do not issue birth certificates. So now, as long as it's in place, um, they should be able to give you the birth certificates. But we have to see after the 19th, even with the injunction orders, like Bhanugaru said, if you don't see an officer not doing his job, they're not an agency not giving you birth certificates, it is something that can be raised. But as long as we have that in place, the preliminary injunction is in place, we cannot stop that from happening. Now, Bhanugar, have you seen any guidance from the Indian consulate or any other consulates that talk about if this comes into effect that they will now start doing like a consular report of birth abroad or something like that?
No, as of today, no, because there is no change in the law. If somebody is born in the land of the US, soil, I mean, we know just soily is the Latin term which we use for this because it belongs to the land of the earth where you were born. And as of today, that's what the 14th Amendment is guaranteeing you. So you're still a US citizen if you're born in this country, irrespective of the status of your parents, you know? And so you are eligible to apply for the US passport and you are eligible to get a proper birth certificate from the agencies and everything until if anything favorable comes to the executive order, then things may change. But until then, you're okay. And I'm sure this issue is not going to solve very soon. It will take time. So, so please do not jeopardize your health by doing any kind of stupidity to have baby delivered early or anything like that. Let the course take its course. I know doctors in this country will be very careful. They won't let those things happen. But I want you to all to be careful with your health, especially because it can jeopardize mother's health and also the baby's health. Okay, it's very, very important for all of you. Just let the course take its course. Now, this child who will be born in March will be a US citizen, so nothing to worry about.
Yeah, in the interest of time, let's try to keep the answer very short, Bhanu Garu and Sai Garu. So yeah, we have 30 more questions to go. Like, let's try to cover as much as possible. So there is a question from Vivek. Does BBI Law Group or Sai Mantra support IER visa program? Have you handled similar cases regarding IER or O1?
Very much, always.
Okay.
Very happy to help them. Ask them to reach out to us.
Thanks. And the next question is from Kiran. My I-94 status is valid till December 24, and we have approved extension till September 27. Is it mandatory to update I-94?
No, the I-94 online will only update when you travel abroad and come back. You already have an I-94 with your H4, with your approval notice, whether it's an H1B, H4, whatever it is. In the bottom of the 797A, you will have an I-94 attached. That I-94, it actually governs into status because that is the latest I-94 that came into effect.
And then, so when you apply for a new one, you might get another I-94 along with it, with a new extension if it gets approved.
All right, and next question is from RB 2023. So maybe I'll call him RB. So the question is, does birthright citizenship apply only to unborn babies or to children who already have, who are already born?
It should not apply to people that are already born. It's effective. It was supposed to be effective for February 19th, but it's not going to come into effect until this injunction is there. Like Bhanugaru and I said earlier, if an officer denies giving them the I guess the birth certificate, a state denies. I mean, here in Arizona, it's the state that gives you a birth certificate. So if they deny giving you a birth certificate, definitely it's something reportable. But otherwise, as long as this injunction is in place, there should not be any issues of getting a birth certificate. And it doesn't retroactively apply. It only so when I say retroactive, from when the injunction is lifted, from if it ever comes in place, it cannot go back retroactive.
Agree. I completely agree. And birth certificates are issued by the state agencies.
So can we apply for Indian passport for the newborn baby?
No.
If we apply for Indian passport, since India doesn't allow dual citizenship, does it mean the kid forfeit their US citizenship?
No, because Indian government does not issue the passport for you.
Okay. Is minimum wage applicable for initial OPT?
I'm sorry, can you repeat the question, please?
Is minimum wage applicable for initial OPT?
Minimum wage is always applicable to any position you work in this country under the Fair Labor Standards Act. Yes. But the issue is whether the position is an unpaid internship position or it's a regular paid position. That's what the requirement is. So that will define whether employer, if somebody is employing somebody as an unpaid intern or in unpaid position or a paid position. And based upon that, wages to be paid or not paid to be determined. F1 students are covered under the Fair Labor Standards Act, so they have to be paid higher at a minimum of minimum wages or higher than minimum wages.
Is it better to change from H4 EAD to H1B?
It's a matter of convenience.
Convenience, yeah. Well,
will the visa holder, a remote employee, be prior informed about USCIS site visits? If someone is working remotely,
so are you going to advance notice for site visit? Is what the question?
What do you say? I'm sorry, I didn't understand. What is the question?
No, if someone is working remotely, will they be getting any prior intimation that there will be a USCIS site visit?
No, site visits are random. They can be sudden and surprise. Only the visits from ICE, especially for STEM OPT audit reviews, for that ICE will give you a notification before they come to audit your company for the STEM OPT site visits. But if it comes to regular H1B site visits, it's random.
All right, next question is from Satya. So recently on Jan 22nd, Jessica Wagon proposed a document to the House of Representatives titled Restoring Immigration Enforcement in America. How scared should we be? And do you think some or all of the document content will be signed into law?
I would love to make this is a political topic, and I don't think we are having a political session over here. But I would love to give them a 2 cents here because, see, the Congress will bring many people to present their point of view, how the policy should be, or any law which they wanted to enact, how it should be, and everything. So they bring in a lot of people, a lot of organizations which have a leverage to the Congress. They'll come and present their point of view with their data, with their analysis and everything. So based upon that, the Congress might decide whether to make any changes to the law or to introduce any bill in the Congress so that bill can be taken forward so that it is better for the country policy and everything. As far as I'm concerned, yes, you will hear so many things like this from anti-immigrant groups like Jessica Warren group from Center for Immigration Studies and from the FAIR, and all these organizations will come because they're all very close to Trump. So they all will come, they present their arguments. Definitely their arguments will be encouraged by the House of Representatives and the Senate right now because they're in the control right now. But it doesn't mean that every aspect of that will be coming into the any bill to be reformed or any bill to be passed by the Congress yet, because it's too early to say. Because there are so many organizations will come up because Judiciary Committee is encouraging these presentations right now and these hearings right now. Let's see how long these hearings will go. So don't worry, don't panic. That's what I'm saying. Do not plan, do not worry, do not panic. What's going to happen? Do your job. That means be today, enjoy today.
All right. The next question from Pradeep Chendupatla is, we hear there are a lot of rumors spread there is no I-140 extension. Can you please confirm if it is true?
That is incorrect. I mean, I'm assuming that he's talking about 7th year extension. I mean, it shouldn't be extension beyond 6 years for the 8th year extension and all those things, but that is incorrect.
And the next question is, done my bachelor's in chemical engineering and master's in software management. Will there be any issue while applying H1B?
It depends upon what position they're applying for. I mean, it's very impossible for me to tell like that. I'm very happy to talk to him in person. What is the position they're applying for? Whether that position will make him qualify for that or not. It all depends upon that.
But there is also on top of it, one thing about I think this question might go to that requirement with H1, where now they're not only asking for a bachelor's degree, there was a conversation about normality versus always. They're just asking for normal at this point. That's the final regulation. And the other thing that came with it is that degree has to be, they don't ask for a specific particular degree. They're asking for a degree that somehow relates to the job duties. So it's not very too stringent as it was first proposed, but at the same time, you can have a degree in a completely unrelated field and be able to apply. So it's not too different from what they were doing from before, but now it's just codified in the language a little bit.
The regulations say that the degree must be directly related to the specific specialty in which employee is going to work or perform services to the employer. It says directly related to the specific specialty. That means it doesn't have to be one degree. There can be several degrees that can be directly related to the field of endeavor in which the employee will be providing services. But the question here is, he did not tell me exactly what the position here is, what he's going to work and what he's going to do. He just mentioned about his education, whether he'll have any problem with H1B program or not. For that, obviously, we cannot answer that with complete answer with common sense.
That's true.
And next question is, when a passport is renewed, do any corresponding things like I-94 or anything at all need to be updated? So basically what he's asking is, when the passport is renewed, do you have to update I-94 or any related documents?
No, they don't have to update. But here I want to really inform the people is nothing related with this question, but I just remembered one thing which is very, very important. Sorry for taking your time, Praveen, here and taking a little bit more longer time in Q&A, because this is very, very important. See, employers, especially employers, if anybody employers are in the calls, and if your employee travels abroad and then comes back into this country, I know I-9 regulations do not require you to do the re-verification of their legal authorization in this country, because you do have a valid H1B petition valid to certain date. However, you have to understand that if somebody travels abroad and comes back into this country, sometimes that validity can be truncated, especially if they have a passport validity is lesser than what time they have and everything. So it's important for you to collect that information from your employee that his latest I-94 or something like that. You cannot ask for I-94. You just ask them to re-verify your I-9 document. There's nothing wrong in doing a re-verification of I-9, because it is nothing in violation if you're doing it for every employee in the company. Okay? Because that helps you that you're not authorized, you're not employing anybody who's not authorized or who's in violation of status. If the status expires, or mistakenly they don't see their I-94, which has been updated online when they entered into this country back again from traveling abroad. So this is two sets which I know regulations do not require you to do that, but I think it's a very good practice and healthy practice in our situation, because I don't think agencies have foreseen this problem with the immigrants, because for I-9 is meant for every citizen in this country. That's why it's important for us as employers having this good practice. I'm very happy to explain in detail if somebody wants to question me on
While
this.
we have that, talking about the employees, what they can do. What employees do is, if you have an I-94 that expires along with your passport, but you have a visa that's beyond it, oftentimes they don't give you a visa that extends beyond the passport expiry. But if that were to happen, if you have a valid visa in your passport and it's just the I-94 issue, you could leave the country and come back and get your I-94 updated. Around here, they're not doing that at the port of entry at the airports anymore. They're actually asking for people to leave. But if you do not have a valid visa, you would have to go to a consulate to get it stamped and come back. And lately, I've been seeing is, if you get a 212G, you don't come back into the country without a valid visa, because then they'll just simply put you on removal and you get detained. So make sure that you have a valid visa stamped in your passport if you ever leave the country before you enter the country. Of course, the passport also has to be unexpired. But when you come back, make sure that your visa is unexpired and you still have a valid visa stamped in your passport before you come back in. Anything otherwise, it creates a lot more trouble than not. And also, one of the things with it is, if you ever get into removal or deportation because of these issues, it could also jeopardize your future entry, like a green card or something, because sometimes it could become an overstay issue.
And also, you can file an extension also prior to the expiration of your I-94 if you can travel abroad. And the right thing to do is filing an extension in this country rather than any other step.
Great. So the next question is, my I-94 and visa is expired and the petition extension is still in progress and yet to receive the receipt notices. So is there anything additional we have to take care at this moment until we receive the receipt notice?
Can you repeat the question, Praveen? I'm sorry.
So I-94 is expired and visa is expired and the extension is in progress and they haven't received the receipt yet. So is there anything that the petitioner has to do at the moment, or just stay put?
If they timely file for an extension and if the extension is properly filed, there's nothing much to worry about. But if extension is not properly filed and if the I-94 expired, then they may be out of status and accruing unlawful presence. So they have to be very careful with this, what they're doing and everything. And also make sure that how long ago they filed the petition and why they have not received the receipt. And also make sure to check whether any checks attached with that petition is being cleared or not also.
Oh,
okay? If checks are cleared, then you're okay. If the checks are not cleared, then possibly is that that petition may be getting written to you for a erroneous filing or anything like that. So you have to make sure that that can really create a messy situation for the employee.
And on top of it, not only the checks, make sure you have the newest edition. The I-129 has been recently updated on the 17th of January. They're not accepting previous applications. So make sure that any forms that you submit along with the checks or anything such as that are the latest edition. Sometimes they, if not just I-129, but sometimes for other forms, they accept previous editions, but some forms come as an edition that they will not accept previous editions. So if you're filing anything yourself, make sure that you file the right forms along with these checks. And then
the form editions, the form edition is very important if you're filing on or after January 17th, 2025.
All right, and the next question is from Amit Kumar. Is there any change on minimum wage for H-1B employees?
No, as of now, no. Every year in the month of July, I mean, on July 1st, the new wage data is released by the Department of Labor. That wage data can sometimes increase the wages in particular geographical location or reduce the wages in a particular geographical location. So every month, the fiscal year starts from July 1st to June 30th for the wage data survey, which is released by the Department of Labor. So that's how your wages are determined for the specialty occupation positions for which the individual will be employed. It could be any specialty occupation position. Doctors are specialty occupation positions. Lawyers are specialty occupation positions. Software engineers are specialty occupation positions. Mechanical engineers are specialty occupation positions. Teachers are specialty occupation positions. Accountants are specialty occupation positions. Why I'm giving you these examples is, don't think that H1B means it's only computer, or IT. Just keep that in mind.
The minimum requirement is a bachelor's degree.
Yeah, at a minimum, in a specific specialty.
In a specific specialty.
The IT is kind of an eye-opener. A lot of people still believe that only IT and related jobs are specialty occupation, and thank you so much. It's really kind of eye-opener for a lot of us. So, and the next question is, if I renew H-1B under premium processing and got it approved, will H4 and H4 EAD be approved along with H-1B? Is there any change in this process?
I'll take this question. So with H4s, as long as you apply a premium with the H1 packet, concurrently all of them together in one packet, then yes, you can, when you do the premium, it gets processed in the premium. But if you do a H4 standalone, let's just say if your H1 application is still in process, but then a few months later you decided I want to apply for another H4. At that point, even if you have a premium process, if you don't do it together, it won't be considered a premium, considered premium under that. Or of course, if your H1 is already approved and now you're applying for H4, there is no, in other words, there is no premium process for H4 by itself. It has to be concurrently filed along with the H1.
Can I add to this? Just want to add to Sai what Sai said. The policy implemented by the USC to accept the concurrent filing of an H4 and H4 EAD along with the H1B in premium processing and adjudicated in premium processing is based upon the case and settlement by the USCIS, and the settlement has been actually expired, sunset on January 24, 2025. After that, it is not mandatory or guaranteed that even if you file concurrently H4 and H4 EAD along with the H1B petition in premium processing, that H4 and H4 EAD will be approved along with the H1B. We have seen in our office, we see several cases where H1B has been approved in premium processing and H4 EAD has not been approved. In some cases, we have seen that happen. So just want you all keep in mind that if your case is not adjudicated in premium processing, don't get surprised.
Yeah, that's true.
All right, I think like it's been over close to 1.5 hours since we started. Is it okay if we continue the session for another 20-25 minutes, Bhanu Garu and Saigar? Or
I'm okay for another 15-20 minutes.
15 minutes, okay. What about you, Saigar?
Can we, like, I'm already a little behind, and you know the reasons of why.
Okay, yeah, I understand. So let's have a hard stop at 7:30 then, and so I'll take up some questions which are very short. So if my STEM OPT got denied on F1, to maintain my status, I admitted to day one CPT school. Can I file H1B? My I-94 is updated when I went outside USA.
Yes.
Yes, okay, great. I recently traveled to Mexico for visa stamping and received a 221G. Since I had a valid US visa from my previous employer, I returned using my new I-797A approval notice, valid until December 2027, with my current employer. However, the CBP did not issue a new I-94 upon re-entry and stated that my I-797A should act as my I-94. My concern is that my I-94 validity date, May 2025, doesn't match my I-797A validity date, December 2027. And my colleague mentioned they should match. I visited CBP offices in Phoenix and Nogales, but they confirmed the same response. Do I need to take any action to update my I-94? Is it fine to continue working with my current I-797A? If action is needed, what are my next steps?
What are the actual validity dates of I-797A? When
December
it
2027.
that is the expiry date, start date.
They did not mention it. I think like maybe we can skip it. And this question
But
is
one thing I do want to
I guess.
one thing I do want to say about it, though, I'm seeing a lot of cases where people are getting detained. This is a very risky thing for people to do. You know, if you get a 212G or they put it in for a waiver, I would not, without a valid visa in your passport, I would not advise people to travel. There are people that got caught at the border.
Very good advice, Sai. I just want to add to this why it is very important what Sai is saying here is, if you get a 221G and if you do not have a valid visa in your passport, then AVR rules does not applicable to you. Okay, that means you cannot, under automatic visa revalidation rule, you cannot enter into this country because you went for a visa stamping in Mexico. But if you have a valid visa in your passport and that visa is not cancelled by the consulate, despite you having a 221G, you can still enter into this country because the visa is still valid.
Yeah.
The only thing is, most of the times people can enter into this country even if they don't have a valid visa is, under AVR, they do not have to have a even valid visa also when they travel to Mexico and Canada. They can come back within 30 days. So if the travel is less than 30 days, they can come back to US even if there is an expired visa in the passport, provided that they did not go for the stamping. And their employment is they're still valid if it's an H1B or their F1 status is still valid, whatever status they are in this country. So it's very, very important. So, and also AVR is applicable for H1Bs only to Mexico and Canada. For F1s, even the Caribbean countries is allowed for AVR. AVR means automatic visa revalidation. Okay. And that's what Sai is telling you guys. It's very, very important for all of you to understand.
All right. The next question is port of entry deportations will increase for H1B re-entry to US?
It's very case by case basis, because the reason, if you look into it, many recent cases where we are seeing people are placed in expedited removal proceedings is that they find some kind of an adverse information in their electronic devices. You know, something happened 2 years ago, 3 years ago, where they worked unauthorized while they were in different status, or they have done some, or they have a fake resumes in their system, or fake experience letters in their electronic devices, something that has been caught beyond what is required, and that is where they're getting deported. And other things is basically is, if somebody is coming to this country without notifying the employer saying that they're coming into this country, that means they're trying to commit a visa fraud to come into this country, because they're not coming to join that employer, but they just want to come to America. You know, so those are the situations where if they get caught, if the officer suspects of these things, then it's possible that they're getting deported, especially in a port of entries like Abu Dhabi, Chicago, you know, Dallas to a certain extent. You have to be very careful. You have to be very careful, especially with the places like Abu Dhabi. They're not properly trained. They're only trained in one way. They only will look into one way. And most of the staff in Abu Dhabi are Asian staff. So they are very, this thing. Even in Chicago also, there is a lot of Asian staff.
Oh my God.
Oh my God.
That's where we
All right. And so the next question is, my H1B is expiring in September 2025. How many months before I can apply for extension? What is the risk in stamping approval? Can H1B holder start INC and do IT consulting in corporation? Basically, he's asking if he can start his own company.
Answer is, I'll answer for the later one. Answer is yes, they can start the companies on H1Bs. But whether they can participate in day-to-day activities, it depends upon what they're doing and whether they have a work authorization to work for that company or not. That means whether they have an H1B approval from that company or not. That determines for them to involve in day-to-day activities. But answer is yes, they can be an investors, they can incorporate the companies. Whether it's an INC or LLC, it doesn't matter. Second thing, and the third thing is, the first one which you asked about is, they can file an extension at least 180 days prior to the expiry of their status.
There is a question from our RVP,
Yeah,
Dinesh Reddy Sudula. People have been getting a lot of 221Gs in Mexico. If we have a valid I-797, can we cross the border while the 221G is in process? If so, what are the consequences?
we just answered that question.
You can talk, Sai.
No, I said we just answered that question
Yeah,
earlier.
it's already answered. Just
Already answered. Okay.
One thing I want to add about the having your own company, with these new regulations, there is someone that's actually you can own a company and apply for your H1 while you're employed by that same company.
That's what I said.
The only difference is the employee control has to be in somebody else's hands.
No. I mean,
the hiring firing decision cannot be taken away.
Yeah, they can. I mean, I've been a big example of that, Sai. In 2009,
yeah,
I did H1B from my own law firm while my green card was pending at that time.
Yeah.
So.
No, I'm not negating you, Bhanu Garu. What I'm saying is, can you throw some light on what the new modernization rules have done?
The new rule says that if somebody has a controlling interest in any entity, that means controlling interest means whether they have a 50% or above interest in the company, or they have a controlling rights to make a decisions in the company, then they can also self-petition H1B from that company as well. But point is, they have to show that they're going to predominantly work in a specialty occupation for which the H1B petition is going to be filed for, besides their job as a CEO or a founder or a chairman of their company is. Those can be ancillary to the position for which they're filing an H1B, but still you can self-petition right now. This is nothing new. This has been borrowed from the tenets of the corporate law, where your corporate entity is a separate legal entity from an individual, and this has been strongly followed by the USA's prior to 2011. I was one of the beneficiaries of that in 2009. Before I got my green card, in 2009 September. Prior to that, while I started my firm in 2008, I just on the safe side, I did an H1B from my own company, by being my firm being a separate entity, me being the beneficiary, and me working as a special occupation, me having a controlling interest in the company, 100% ownership in the company. So same thing, they brought back into these regulations, which is a good thing. But you have to establish that there is a bona fide, a genuine activity in the company for which you're trying to petition your self-petition your petition. You just can't park yourself into that H1B program and go and do whatever you want to do other places around. That will get you into trouble. And that is the problem I have with the recent calls or with the recent thinking, is that people will try to exploit this particular benefit given by the USCIS in the new regulations, and that will get you into trouble for many people unnecessarily. So be careful on how you do that.
Can you also advise on the employee control when that kind of a structure happens?
As I said, being the 100% owner, being this thing, they can do that. He has to establish that he's the owner of the company and is providing specialty occupation services. Sometimes being an owner of the company, you can also control your job also. You can establish that. That is not a problem. USS it's not going to go detail into that. But only thing is, they're going to issue the approval only for 18 months for the initial petition, and also 18 months for the extensions or amendments or anything you're filing later on also. So instead of 3 years, they're going to approve it only for 18 months.
Yeah, and I think we are out of time, but I'll just ask last two questions before we wrap up the call and hand it over to Vasavi. So last but one question is 6 months payroll not processed for me last year. Is it a problem for me at the port of entry when I go to India and come back this year? I'm on H1B.
This is a very specific case pattern for one individual, we would love to talk to him privately. Kindly ask him to reach out to me privately. I'm very happy to talk to him and guide him.
Sure. And before I start the last question, a request to everyone. I know there are still more than 50 questions pending, and in interest of time, and we have to respect our attorney's time, and they are so kind enough to accommodate their schedule, though it's a busy season. So, in case if you need any consultation, we'll be providing the contact details of Bhanu and Sai. You can reach them out offline and talk to their office to schedule an appointment. And one last question I have from our guests is. This is most common question and very interesting question. So, do speeding violation lead to H-1B denial?
No. Just regular speeding violations is not going to cause a denial. But if it's a reckless driving and if it has an intention, or some states, reckless driving can be punishable at least in a year or more.
If hit somebody.
Okay, and let me ask the question in a different way now. It's not just a speeding violation, but if it is a DUI, will it lead to H-1B denial?
Still, it's not H-1B denial.
So essentially, what happens with these things, as Bhanu Garu has said, is the most important thing is anything over a year. If the statute says for something that you do, if the sentence is going to be longer than a year, or if the actual sentence is more than 6 months, it becomes a problem.
Not or end. It's not or, it's end.
Yeah.
It's end. The maximum possible sentence is
also,
1 year or more, and the actual sentence is at least 6 months or more, then it can become a problem for him.
But if a felony, you could have 1 year worth of anything with a felony
it's 1 year or more. If it's 1 year, it can be misdemeanor also.
So 1 year or more is always there. For anything less than that, if it's more than 6 months of imprisonment, it also becomes a problem. That's where the and comes from.
And comes from.
Now, that being said, when we talk about these DUIs, in the statute, reckless is a problem, regardless of what crime it is. If it is a reckless crime, it becomes a problem, and it can be both deportable and inadmissible. Now, that being said, one another thing about
matter of Sylvia Tirano, right? Matter of Sylvia Tirano, right? That's what you're talking about, right?
Yeah. And then one last thing about this, though, is sometimes you could if you have 2 offenses, some of these, even if they are smaller offenses, if you have 2 offenses in 2 offenses, that also could become a problem. But again, these are very specific when in instances that people actually go through. If that is the case,
yeah, but in general DUIs or general speeding tickets do not cause issues with your H-1B status in this country. However, if you have a DUI, if you go for a stamping, you have to get a certificate from the Surgeon General saying that you are not a habitual drunkard to apply for a visa. Because your visa, Department of State regulations demand that they revoke the visa if there is any existing valid visa in the passport if somebody is charged with a DUI.
So the issue is not the DUI itself; it's the alcohol addiction. If they think that you abuse alcohol, and that's what you're getting certified, is that you're not an abuser of alcohol.
They won't issue the visa for you if you don't get the certification.
Period. Yeah, exactly. But that's what they're looking for. Now, one other thing, you didn't ask Praveen Bhai, you asked about DUIs and traffic tickets. One last thing I want to mention, don't get into DV problems. Domestic violence problems is a big problem with immigration, so do not get into those.
Absolutely.
I know,
So the last question,
Sai Garu has dealt with a lot of such problems for DUI or domestic violations, and he ensured that both parties are happy end of the day. So he's a great family lawyer too in Arizona, and he helped a lot of my friends in such situations. So yeah, thanks Sai Manthra for all your services, and of course, a lot of people already know Bhanu is he's a word I don't have words to express, but maybe you can Google about the lot of good things he does. And Vasavi, can you please share the screen showing the contact details of
sharing the
Sai and Bhanu?
screen.
Yeah.
Yeah. Thank you, Praveen Garu. And Bhanu Garu, there was a lots of question. Can you please share your WhatsApp group number? Because many people are asking.
Sure. My WhatsApp group number is 319-400-0053.
Yeah. Can someone type it on yeah, please do that. So that
319.
That's correct.
Okay. Also, can you share, Vasu, can you share their business information? I think we have a slide for that, right?
Yes.
Yeah, also Sai Mantra's number. Can you please place someone?
Yes.
Just pull that out and yeah, share for a minute so that like they can.
So
Yeah.
this is a business card of Bhanu B. Ilindra Garu. And I hope everyone takes a screenshot. And if yes, please just give a thumbs up. Then I can move to other screen.
Yeah. And also post this, visiting details, right? In our TTA WhatsApp group also.
So definitely, sir. Yeah, this is our business ID, business card for Sai Mantra.
On a light note, Sai looking very handsome there.
Oh yeah.
He's always handsome. You should visit us during our
So Sai
Dasara
requested
Bakkama
to keep a
events. He's
handsome
always the
photo.
winner for our fancy dress competition.
Oh, really? Nice. Nice.
Sai
Next time I come
requested to
there,
give a handsome look actually.
Yeah, next time when I'm in Phoenix, Sai, definitely we should.
Yeah, definitely, Bhargav. We should meet.
Awesome.
All right, and it was definitely a great session. And before I hand it over to Jyoti Garu, so I just want to say a few words and thank you all the guests who joined, and it was really intriguing and insightful conversation. And on behalf of TTA leadership and Arizona team, so we would like to thank everyone who joined our U.S. Immigration Policy and Reform webinar. And we really appreciate all the insights provided by Bhanu Garu and Sai Garu. And it's been your expertise and your experience matters a lot. And this is definitely the need of the hour for a lot of our Desi crowd. And this session, I'm confident that would have enlightened a lot of our Desi population who are really struggling about. I know, like after this Trump 2.0, like it has created panic, and a lot of people are anxious about like what's going to happen. And this is definitely enlightening. And thank you so much for all your insights, Sai Garu and Bhanu Garu. And we hope all of us are walking away with a clear understanding of the changing immigration policy. And yes, we are on behalf of TTA, we are going to conduct a lot of such insightful sessions. And for anything, right, as I think like more reach for individual consultation, I request all of you to reach out to Bhanu Babu, Ilindra Garu, and Sai Mantra Garu. And yeah, thanks everyone, and looking forward for more such insightful sessions. And over to you, Jyoti Garu.
Yeah. Thank you, Bhanu Garu, Sai Garu, and Vasavi. And definitely TTA. It is on behalf of national organization TTA. Lot of people got benefited out of today session, and definitely many people who are with pain, they got answers from Sai Garu and Bhanu Garu. Bhanu Garu, you explained very well the meaningful and answers, and everyone got to know that how they rectify the problems, and also you reachable to everyone, that I understand. And Sai Garu, it was wonderful, and lot of experience, got it out of your answers, and definitely it is a benefit for each and everyone. Also for us, also it is knowledgeable and knowing answers. Someone asked, quick answers we got from you all. It is definitely honor to know all these. And thank you, our AC. Thank you to founder Mallareddy Garu, and EC and Extend EC. And thank you, brother Shiva Garu, and absolutely my brother Praveen Samala and Arizona team. RVPs and standing committees, all of us, worked very hard, and it is great, insightful, and benefited, session today. Thank you, everyone, and good night.
Our team, state coordinators and standing committees, Shravan Gampa, Ramakrishnan Allah, and our RVPs, Vinod Gardas, Anup Godishala, Dinesh, Vasavi, and Avinash Nandiala have been working very hard to get it done. And kudos to everyone that has participated.
Yeah.
And thank you so much. Thank you so much, everyone. And Vasavi, great job today. Keep it up. Let's keep the ball rolling, and a lot of good things ahead, guys. And once again, thank you so much to TTA leadership, and thanks Sai, Mantra Garu, and Bhanu for accommodating in your busy schedules. And it means a lot to us and the community. And let's keep this going, guys. And thank you so much.
Yep. Thank you everyone for joining the webinar. I think this is a useful session for everyone. We have, I mean, Bhanugaru and Sai Garu has cleared so many of the questions and gave a great clarifications on birthright citizenship especially. So thank you everyone. Hope we'll come up with more immigration webinars soon. As the new laws comes, we'll come up with the new challenges and the new webinars with the new attorneys, whoever is in. So please join our WhatsApp group so you can be updated what's going in TTA Arizona. So signing off, Vasvi. Yeah, thanks everyone. Thank you Naveen Garu and team from all over the chapters, who are all the RVPs who have joined from throughout the TTA chapters. So thank you everyone.
Thank you very
Excellent
much.
job, everyone. Thank you so much. Have a
Thank
good
you
night.
very much for everything.
Thank you. Thank you.
Thank you.
Thank you. Good evening. Good night,
Thank
everyone.
you. Chalo, namaste. Good night.
Thank you all. I'm going to now end the recording.